Okay, can you hear me okay?
Yes, sir.
Thanks, Lynn, for wiring me. Usually my voice carries, but if you have any problems, let me know. I've got 3 handouts tonight, or this afternoon, and I want to ask Roger and Dan and Chris, yeah, come here. We're going to give you this, we're going to give you this, and Dan, we're going to give you this.
Okay.
To pass it out.
One per couple, you said.
One per couple. We may have enough for others, I don't know, but one per couple should be sufficient. If you don't mind sharing with one another.
Larry, I think there's enough for everybody.
Oh, okay, great. You're welcome to make notes. Let me just explain what we're going to do here. And so you'll know, this is going to be a presentation given in 2 phases. And I want to thank the church, and I want to thank Matt Nephew for giving me this opportunity. And it is being videoed, and Matt will have it available on his YouTube site. And the reason for that is twofold. There are some people that came up to me that said, Larry, I'm going to be out of town this weekend. I'd really like to know more about estate planning. And so it allows those people that are not here today an opportunity. If they want to look at Matt's YouTube on this session, they can do that at their leisure at home. And the second reason is that there will be a lot of material that while I'm trying to keep this simple, there'll be a lot of material that people will go, gosh, I didn't get that. And so you may want to look at the YouTube a second time. Okay? So by way of introduction, I think most people in this room by now know I'm Larry Foerster. I'm Martha's husband. That clarifies it for a lot of the ladies in the room. And get some feedback. All right. He's working on it? Okay. Well, while we're going through that, I'm just going to continue. And again, there should be handouts for everybody here. I'm coming up on April, being 50 years that I practice law.
Wow.
So you're still practicing?
Yeah. Eventually I might get it right if I have another 50 years. And I was sitting in the church, I guess, a month or so ago, and I looked around and I said, given the experience, thank you. Given my experience with people that have estates and so forth, it just hit me that one of the things I could do before I totally retire is to help people along with their fears about estate planning. And I'm hoping that this session will go well enough that it will plant some thoughts in your mind, will answer some questions, and so forth. So what we're going to do here today is the first part of it, if you've got your handout, and I'm looking, yeah, here we go. You should have a handout, front and back, that says estate planning at any age. Estate planning at any age. That's what we're going to be working on on part 1 of this 2-part series. And what I'm going to be doing is I'm going to be going through my outline. It helps me stay organized. I'm sure there'll be questions. Frankly, I hope there are questions. But I'd like for you, if you will, to just keep your thoughts and your questions at bay until after I get through the outline, which will take maybe 30, 40 minutes. Then we'll have plenty of time to answer questions. And I want to tell you that in my experience, there are no dumb questions when it comes to this. So if there's something that you want me to elaborate on, or if there's something you missed, or something that I didn't cover that you have a question about, please ask it for the benefit of everybody in the room, okay? There's also another handout that I'm not going to cover, and it's called Probating a Will, Frequently Asked Questions. And it's a 2-page document. You can just take that home with you. But it will cover a lot of the questions that frequently asked questions people have about probating a will. And so this is something that you can use and look at. And so what I cover in the first session today will be touched on by this, but I'm really not going to use this handout. It's just there for your benefit. After my walking through estate planning and your questions, if anybody wants to stay, we're going to cover what's called, I call it, it's just my small estate will worksheet. And this is a fill-in-the-blank kind of thing that you can use, but it also provides you, as you'll find out, a lot more information about what you should be thinking about when you're doing a will. And we'll touch on a little bit more on powers of attorney and the like. But there's going to be questions, particularly for some of you that that are married and have children, some of whom might be under 18 years of age. And you're going to want to think about, well, who do I want as the guardian of my child? And you're going to think about, well, do I want to set up a trust, what we call a testamentary trust, within our will to deal with caring for our children, taking care of the financial issues if we're both dead and we've got minor children at home, and yes, we got a guardian, but maybe that guardian or guardians are not best suited to handle the estate financial affairs of our children, to protect our children's assets till they get old enough to grow up and handle it themselves. So we'll cover some of that in the second session. The first session is just an overall discussion about estate planning, things that you might want to know, things that you should know, I think, in estate planning. And as I said, I've done this a long time. When I first got out of law school, I worked for a law firm in Orange for about 3 or 4 months before I went on active duty. And we did everything there. One of the things we did was we helped people with their wills and for probate. And I did that for a short time. Then I went into the Air Force for about 4 years, and I did a lot of this when I wasn't in the courtroom or handling other legal matters in what we call the Judge Advocate Office at the Air Force Base. We did a lot of will work and estate work for all the Air Force people on base. So the 2 different bases I worked at, it gave me an opportunity to learn more about what people need and what they think about wills. And then after serving as coming to Conroe in '78 and 3 years as an assistant DA and then 4 years as the county attorney here, I didn't really do a whole lot during that 7-year period. But then in private practice for the last 35 years or so, we do a lot of that. And my practice has really dwindled down as I'm trying to phase out, and got it down to about 7 days a week now. So you're laughing about that, but Martha says, no, that's right. Again, there are no stupid questions. I realize that you'll have questions, so please hold off until we finish going through the outline. I'm reminded, one of my favorite stories about lawyers is the story about a lawyer, a doctor, and an engineer that were all sitting around arguing what was the oldest profession of the 3. And the doctor said, well, look in Scripture. The Holy Scripture says in Genesis 2 that God put Adam to sleep and he removed a rib and he formed Eve, and that's a medical procedure. So medicine has to be the oldest profession in the world. And the engineer said, no, wait a minute. He said the engineering is oldest because in Genesis 1, if you go 1 chapter up to the beginning, there was all this chaos, and God created the world from all this chaos that was there. That's a loose translation, but humor me. So the doctor says Genesis 2, engineer says Genesis 1, and the lawyer stopped him and said, wait a minute. Who do you think created the chaos? Somebody got it? All right. So my goal is to not create chaos. My goal is to try to bring clarity to these questions. With that being said, then turn to your estate planning at any age handout, and let me just walk you through this, and I'm going to move fairly quickly, but I'll stop and elaborate on as we go along. What is estate planning? Let's just start there. It permits you, and I emphasize you, to control and manage your property before and after your death. It reduces problems for your loved ones during your life and after you die. It reduces legal costs to your spouse and your children. It protects your estate from unnecessary federal taxation. Now, frankly, unless you've got a large estate, and we'll talk more about that in a few minutes, federal taxation is really not going to be an issue for most people in this room. If your estate's in excess of $12.6 million, then we need to talk. And it's important for people who have children, who own a home or other real property, and have accumulated other investments. And finally, and I can't emphasize this enough, it's good stewardship for what God has given you. Regardless of how little it is or how much it is, God has entrusted this, whatever He's given to you, and you need to be a good steward of it to make sure that it's properly directed where you want it to go, and to reduce legal costs and all the other complications that go with estate planning. Let me emphasize right now, for those of you who live in Texas, and I assume everybody does, you couldn't be in a better state to live, to probate an estate, because it's really simple in Texas, okay? As the probating the will handout will tell you, it takes between 3 and 5 weeks to probate a will. If you came in to me today and said, Larry, my spouse died, I need to probate his will, we could prepare the application, probably file it by the next day, and about 3 to 4 weeks later, we'll have a probate hearing. We're doing those by Zoom now in Montgomery County, and most counties are going that way. So, you come back to my office, and I ask you certain questions. Takes about a minute, and it's over with. Okay? Really simple. Really quick, really simple. Assuming you've got a will that's properly done, properly executed, has a few words in it that are sort of magic words. We'll talk a little bit about that. So, there are so many people that get so frightened about probate, and it's totally unnecessary. It is really, really simple. And I can't tell you how many times over the years I've had people tell me when it was over, they look at me and said, well, you told me it was going to be simple, but I really didn't believe it. And it is, okay? Again, assuming you do a few things that we're going to be talking about today. So why do I need a will? I get that question a lot. And if you have absolutely nothing, if you own nothing, you have no family, you probably don't need a will. I had a grandmother who died many years ago now, and she lived with my parents, and she had no real estate, she had no investments, she was living on Social Security, and that was about it. And we didn't need to probate her will. I can't even remember if I did one for her. I don't know that I did, because she didn't have anything. And all of her kids were grown and so forth. But if you don't have a will, the state of Texas, by law, has devised a will for you. So the question is, do you want to control your assets, or do you want the state of Texas to do it? It's that simple. We call, if you prepare a will and you have a will, we call that testate succession. Whereas you have a testament. A will is your testament as to what you want, your statement as to what you want to do with your estate. If you don't have a will, then it's called intestate, meaning the state's going to take care of, it's going to tell, it's going to dictate by law who gets what. Okay? So, one of the things you want to do in a will is it allows you to identify your heirs and what part of your personal estate, if any, you want to give to each one. Now, most people, if they're married, they say, I want to give everything to my spouse. I want to give everything to my wife. I want to give everything to my husband. And then generally they say, I want to give everything to my children. But there are exceptions to that, where there may be other people you want to account for. I had a guy come in the other day. He wanted to make sure that his mother, who lives on the property where he lives, and built a house on the property where he lives, that she could be taken care of in terms of her house. There may be things that you want to pass on to other family members. I've had people come in and I've had some guys say, I got a great fishing boat. I've got a buddy that I fish with. I wanted him to have my fishing boat and trailer. That's a special bequest that could be in your will. Or you may have certain items that you want to give to certain people in your family, certain jewelry pieces, certain furniture pieces, certain real estate pieces that you want to give to certain members of your family. You can set that out in your will. As I said, specific bequests can be given in charities. We're probating one now where this lady had quite a bit of money. She had no children. She just had a lot of nephews and nieces, but she wanted to give money to 4 different charities that she supported, and that's set out in the will. So it could be a church or any favorite organization that you like to support. You can give them some money. Another thing it does is allows you to identify who you want to raise your children if you're both dead, assuming you've got minor children. Who do you want to be the guardians of your children? And that's not an easy decision. I've seen couples challenged over that because they have different ideas of who's the best person to raise their children. And obviously, it allows you to also identify an independent executor, a person that's going to serve typically without bond. That saves a lot of cost right there to make sure that the will says they can serve. I trust them enough. We don't have to post a bond to make sure that they don't rip off the estate or misapply the estate. So in Texas, we have what are called independent executors. They're spelled out in the will, and they typically say they serve without bond. Some of them can be compensated if you choose to do that, and that can be provided in the will. And a lot of times you just do it because the person is your spouse or a child or a brother or sister that you trust, and they're just going to do it for love and affection. They don't expect to be paid. Obviously, they're entitled by law to be reimbursed for any of their personal expenses, but on the other hand, they are not going to be paid anything other than what they may get in the will itself. One of the things this does, and a lot of people don't think about, is most of the wills I do for people that have children under 18, minor children, that haven't become adults, is I set up what's a testamentary trust. That is a small, simple trust within the will that says, if I die, my spouse is dead, we're both dead, and I've got minor children, I hereby give everything I have to my children equally. Let's say that's the typical way it's done, with a caveat that until they reach a certain age, their proceeds are put into a trust held by somebody that you trust to take care of their medical needs, their education needs, their physical needs, and so forth until they reach a certain age. Obviously, it could be age 18. For Martha and me, we did ours at age 25. because we wanted the kids to get a little further down the road through their stupid years,
Yeah.
you know, where they have maybe if they go to college or they go to vocational school or they're out on their own, we want them to have go through a lot of mistakes and maybe learn the value of what they've inherited further on down the road. I've had some clients that have set that at 30 or 40 years because they absolutely don't trust their kids' judgment. I caution against it for a number of reasons because it puts a burden on the trustee primarily. But I mean, that's part of what you can do within there. Or you can set up something where you've got, let's say, a child who is mentally handicapped and they're going to turn 18 and they're certainly not competent to take care of themselves. So you can set that up so that somebody's going to be responsible for their health, maintenance, and welfare, maybe for the duration of their life or for quite some time beyond that. So those are things that can be done that a lawyer could help you do. Okay. Again, this is more, I don't want to make this complicated. These are really simple for a lawyer to do, and I could do that, or anybody could do. Any lawyer that does probate work could do that. But it's food for thought. Okay. You don't want to die, and your child is 18. And what are they going to do? They're probably going to go out and buy the biggest truck they can find, or have the biggest party, or whatever they're going to do, because your kids are no different than you were at that age, right? We were all stupid at age 17 and 18 years of age. So that's why you want to protect them from themselves for some period of time. The testamentary trust also provides protection for spendthrift heirs. That's what I was just talking about, where they want to spend everything as soon as they get it. And you give them some time to grow up and mature. There are tax savings for large estates, something like $12.9 million in federal taxation is the threshold. If your estate is less than that per individual, then you don't really have to worry about federal taxation. And there is no Texas inheritance tax, which is really great. Okay. I mention all that because there's other states where it's much more complicated. I don't know that we've got Don and Sherry Lewis in here, but they've got trust because they came from California. And they'll soak you in California with all the probate rules and laws. And so in other states, it's not uncommon to set up a trust to avoid some of the taxation issues and to avoid having to even go through probate. And obviously another thing it does, allows you to pass your real property and any maybe oil and gas or mineral interests you may have. You may have inherited some mineral interest from somebody and you may want to pass that on to somebody outside of your children. So that's another consideration. And I'll mention this also. For those of you who have been married more than once and you have children by previous marriages, you got to deal with that. And the will allow you some latitude as to how you're going to be taking care of his children and her children and your children collectively in some cases. So those are things that you can be made aware of. Again, process all this because we're going to be fielding questions here in a few minutes. Then the next item 3. Why do I need powers of attorney before I die? Let me emphasize that a will is only triggered upon your death. Prior to your death, most people, we encourage you to have a power of attorney. And typically we do 3 powers of attorney. One's called a statutory durable power of attorney, which allows your spouse, or if your spouse is dead, a child or a close friend or a relative, to have some responsibility to serve as your agent to take care of your affairs during your lifetime. Well, why would that be necessary? The biggest reason why it would be necessary is because as we get older, we can either find that we don't care to take care of our personal affairs because we're getting elderly and whatever, or we may get dementia, or have some other issues that affect our ability to take care of our day-to-day personal business. So we can delegate that and as an agent to another person. Our spouse usually is the first one, or someone else, a child, brother, sister, good friend that you trust, that can be responsible for the business affairs, your insurance transactions, your banking transactions, and all these kinds of things that are the day-to-day things that we deal with, making sure your taxes are paid and so forth. The next one is the medical power of attorney. You know, in Texas and throughout the United States, we have what's called the HIPAA rule, which is what you sign every time you go to a doctor's or dentist's office, and it says, I authorize the following people to have access to my medical records, okay? But let's say you get ill and you're heavily medicated for a time, or unable to make decisions about your medical care. These medical powers of attorney list those individuals that the doctor can confer with to discuss what procedures are in your best interest health-wise when you're not able to make those decisions for yourself. And it has a HIPAA release, as I said, which allows the doctor to even share this medical information with you. You know, technically, if you didn't have that, and that's why doctors have you sign that, and dentists have you sign it, every time you check in and start filling out all the paperwork you have to fill out for a new doctor, they have you do that because they want to know that they have your authority to share your medical information with somebody else that you trust, okay? So we put that into the document, although that may already be available at every doctor's office you sign. You just simply don't know where you may be sometime when that document, some doctor's office where you've never been before. And now that doctor is having to deal with your medical condition. And now you've got your agent, your loved one, spouse, or whomever, can hand that over, and they'll typically scan it into their system and give the original back to you. But that's an important document to have. The third is, in Texas they call it a directive to physicians and family. Some people call it DNR, where it is do not resuscitate, or it is, I call it the pull the plug directive sometimes, where you have thought about what you want to do under certain circumstances. Doctor says, Larry, you're eaten up with cancer. We don't see you living more than 6 months. So, we need to know, Larry, what do you want to do? Do you want to be kept on life support even though it won't prolong your life? Or whether you rather be taken off life support and be given medication to keep you comfortable and pain-free and allow you to die as gently as possible. That's called hospice. So those are two options that fall in there. The second is where you have been, where it's not terminal, but it's a condition that's irreversible. I think commonly of somebody that has a severe terminal, or not terminal, but permanent brain injury, where you're never going to be able to care for yourself, make decisions for yourself. You're just going to be laying there. I had a grandmother like that, same grandmother. I hate to keep using her as an example. But, and Martha went through this with me. My parents were still alive at the time here, and every day, my grandmother had fallen into a coma. She never came out of it. And so for every day, for 2 years, my parents would go to the Autumn Hills nursing home on North Fraser, and in the morning put her teeth in her mouth, say prayers over, maybe sing a few hymns, thinking that maybe she could hear something through that coma that she was in. And every day for 2 years, they'd go back at 5 or 6 o'clock in the evening, take her teeth out of her mouth, say a prayer over, maybe sing a hymn or two, and they did that for 2 solid years. Martha knows what we went through, because my mother had never asked her mother what she'd want to do if she fell into a terminal or a permanent condition like that, where she had no quality of life and so forth. Don't put your family in that situation, okay? Think through that and share with them what you want. And this is probably a good time to point out, once you make these decisions, make sure that they know what your decisions are and why you're doing what you're doing. If, for example, you want to leave more to one child than another, that's within your total prerogative. But you might want to stop and tell them why. The sad thing for me is when I have people come into my office and say, we've got 4 kids, 2 of them we haven't seen for several years. They won't let us see their grandkids, and I don't want to leave them anything. They have disowned me. They have no relationship with me. I don't want to leave them anything. So we have to carefully craft that language in there to make sure that we can avoid that. And boy, it's a great opportunity to ask them questions. They'll share all kinds of stuff with you, you know, because they'll open up. Because I'm always asking the question, are you sure you want to do that? And they'll share that with you. So, again, you've got the latitude to control what you want to do with your state. And I have other people come in and say, listen, I've got 3 children, 2 of them are really doing well. They make more money and they live in a bigger house than I do. But I've got this one child over there, she's got problems. You know, she's struggling, maybe she's a single mother, she's got kids. I really feel like we needed to give more of the estate over there. Not that I don't love the other 2, I'm really proud and love them for everything they've accomplished, but this child over here needs some special attention, and I want to give more of my estate there, or maybe I want to set it up in a testamentary trust because that child is so goofy that while I love her and I want her to have stuff, I don't want to trust her with it because she'll spend it like she did everything else. Great stories that you hear. I ought to write a book about it sometime, but it would be a violation of the legal ethics. All right, number 4. At what age should I get a will and do powers of attorney? Okay. Well, obviously, the answer to that depends on your circumstances. Obviously, whether you own anything or have anything or hope to acquire anything, whether you have children. But I will tell you this, just from my experience, and I'm not saying this is what every family needs to do, but as soon as Emily, our oldest, turned 18, she had a will and powers of attorney. And 2 years later, when Daniel turned 18, he had a power and a will and powers of attorney. Because if they got involved, for instance, in a car accident, and they were killed or the like, well, if they were killed, for example, I would have the authority, because I typically was named as the executor of the estate, Martha was the backup, to wrap up the affairs of the estate, to take whatever action needed to be taken on behalf of their estate. If they got ill, and particularly if they were single, and if they're not listed on a HIPAA release, a medical release, technically as a parent, I don't have authority to look at their medical records. In fact, they're 19, 20, 21 years of age, they're in college, I don't have authority to look at their medical records. Now, most doctors, to be honest with you, will go on and do that because they know the circumstances and they're going to say, to heck with that, this is an important thing, and I'm not going to worry about that because this is a child whose parent needs to know. But that technically is an issue. And so, am I telling everybody in this room, gosh, you got an 18-year-old, 19-year-old, 20-year-old, 23-year-old that's single, run out and get wills and so forth for them? Use your own judgment. Use your own judgment. 5, how much does it cost to have a lawyer prepare an estate planning package? That is the will and the powers of attorney. That depends, first of all, on the complexity of your estate. And incidentally, as I told Dave before I started this, I'm not, if I do anybody's will here, it's for free. I'm not doing any, this is not a moneymaker for me. I'm happy to share this information. But if you go to a typical lawyer, depending on, if you just say, I want a simple will, and I always smile when somebody says, I just need a simple will. Then they start telling me about, well, I got these kids I don't want to leave anything to, and I got these minor children over here, and I've got, and you know, what was a simple will is not a simple will. If it's simply, I'm married, I want to give everything to my wife, and if we're both dead, I want to give it to my children equally, that's a fairly simple will, although you might want to put a testamentary trust in there to protect these minor children. The answer to that ranges for an individual, anywhere from $400 to $1,000, maybe more, depending on the complexity of it. Do not, as I point out in this, in the probate, shop for a lawyer. You'll get different pricing. And if you call me and said, hey, you know, Larry, what's it going to cost? I'm going to say, to be honest with you, it all depends, but this is the range that in my experience we're talking about, okay? And sometimes and we'll get into this a little bit more in a minute, there's other things you can do to avoid probate, and we'll touch on that a little bit here in a minute. But, and most lawyers will work with you. If you come in and say, you know, it's going to cost $1,000 for me and my wife to do wills and powers of attorney, they'll work with you and say, okay, we'll do a payment plan or something like that, because they know that you can't write a check for $1,000. Most people can't. A lot of people it's difficult to write a check for $100, you know, particularly in the world we live in today with the cost of living. But don't let that dissuade you. There's a couple options that you can do that don't avoid where you can avoid a lawyer, and I'll talk about that briefly here in a minute. Number 6, can I save money by using a will form from a computer software, legal package, or an office supply store? And how good are those forms? I have seen some really good forms. LegalZoom seems to be the most popular. There's probably other software companies out there that will do them, and they're tailored to Texas. The challenge is they give you these questions, you got to fill them out, you know, and when you're working through that, then you'll have a pretty good idea. They'll process. The software will sort of process what your will look like. And I don't know what those things cost. Has anybody done one here? I'm thinking they used to be $75. They may be a little bit more than that now. But they can be pretty good, particularly for a simple husband and wife will with kids. Okay, they can be pretty good. The challenge with those is that people, even if they complete them properly, fail to execute them properly. Meaning, they don't sign them. Or they get all their relatives in the same room, and the people that are inheriting are the ones that are listed as witnesses to drafting the will. In Texas, a properly executed will will be signed by the person signing it. We call it the testator or testatrix if you're a female, or whatever the gender. I don't know what it is now in the transgender world we live in. But that testator will sign it in front of 2 witnesses and a notary. And so there'll be what's called a self-proving affidavit. After you finish the will, there'll be a place where the witness is signed in front of the testator, and then 3 of them are signing in front of a notary. Once you do that, that's all you need to probate the will. You never have to chase those witnesses down again. You never have to worry about, oh gosh, where are my witnesses? It's a self-proving will signed before a notary, and that's all you need before a judge, making it pretty simple, okay? But I've had situations, we've got a situation right now where I did wills for a young lady, friend of ours, that's moved from here up to Bullard, Texas, and she and her husband, I explained it to her. I mean, she's college educated, she's very bright. I explained it to her, and she screwed it up twice now. She'll mail me a copy of what's executed, and the first time she had her 2 parents sign the will. I said, no, you can't do that. So then she redoes it. We sent it to her in PowerPoint so she could print them off there. She and her husband did it again. And she had the witnesses sign one date and the notary sign another. That's not going to fly with the judge. Okay. So my point is, if you're doing that, make sure you follow the instructions that LegalZoom or whatever will have. I had somebody just the other day say, well, I got a will from Office Supply or Office Depot and did it. I don't know. I haven't seen those. They may be tailored to Texas. I don't know. But once again, they're just sort of fill in the blank, and you know, you may not know what you're filling out. Okay. I get people that come in, they moved to Texas from California or wherever they are there. Maybe they had a will there, or you know, from North Carolina, wherever they are, RSCJ back then. I haven't seen his will, so I don't know. Maybe have I seen your will? Maybe I have. Yeah. And you know, incidentally, I'm happy to, for anybody that just wants me to look at their will, I can tell you in a minute whether the will's going to fly in a Texas probate court. But they'll come in and there'll be something like, it'll say, I give everything to my personal representative, and maybe it doesn't reference that there's a bond. Well, in Texas, the magic word to become an independent executor is the term independent executor or something similar to that. The word independent is really important in Texas probate. Otherwise, the judge says it's not independent, and I'm going to have to approve, the judge is going to have to approve everything you do as the personal representative or executor of the estate. You don't want that, folks. You want to be an independent executor so that once you're selected, that's probably the last time you're going to see your lawyer, unless there's other documents that need to be done. Okay? So again, those forms can be good forms if they're properly executed and if they cover everything that needs to be done. And again, I'm happy to look at any wills you have, and I know what words to look for, and in a matter of a minute or two, I can tell you whether it's a good will, and most of the time they are. Most of the time they are. So if you're going to go that route, I don't discourage that. Just make sure you follow instructions very, very carefully. Number 7, what about a handwritten will? We call it a holographic will or a testamentary letter. Texas allows for what are called holographic handwritten wills. So if you don't have time to see a lawyer, or when you get home this afternoon, you can get a piece of paper and say, I, Matt Nevue, put the date on there, and in Matt Nevue's handwriting, Matt could write, I give everything I have to my wife Kelly, and I name her as the independent executor of my estate to serve without bond. If she should predecease me, I give everything to my 2 children equally, and sign it in your own handwriting. That's a valid will, and it can be probated in court. Now, you have to have a couple of witnesses that can testify that that's Matt's handwriting. I recognize that, and I know that he was competent when he signed that on August the 27th of 2023. Okay, so that will can work. I'm amazed at the number of lawyers that don't have wills, and maybe they have a holographic will. One of the most highly respected legal minds in Houston was Gerald Treese, professor for probably 25, 30 years at the South Texas School of Law. And I was watching the Zoom probate hearing, this is probably 2 years ago. I didn't even know that he passed away, but he was, a lot of people had seen him on TV because he was a great legal mind and a Christian. And there he was, a lawyer was probating his handwritten will. One of them, I mean, he teaches law students for 25, 30 years, and he didn't have anything but a handwritten will. Well, it got probated, but I was just going, my gosh, you know. And frankly, there are a lot of lawyers that have never done wills. That's not their deal. They or criminal prosecutors or family lawyers, and maybe they don't have wills, maybe they do. But a lot of people put it off. It's like the mechanic that, you know, if you look at a mechanic, the guy that works on everybody's car, his car's falling apart because he didn't have time to work on it. He's so busy working on other people's stuff. So that does happen. My point is, a handwritten will can be used. So that's one way to save some money. Just make sure you identify yourself, you have the date on that. Everything has to be handwritten. You cannot type it. Cannot type it. Has to be handwritten. Cursive or printing, whatever, in your hand, so that somebody, when you die, that knows what your handwriting looks like, can say, yep, that was Matt's handwriting, that was his signature, I recognize it, and that'll validate it in front of a judge. So it needs to be dated, handwritten, and signed. And you know, again, some of the things you might want to put in there is identify who you want to leave it to, identify who you want to be the executor of the estate, independent executor of the estate, to serve without bond, sort of magic words there, common sense. And if my spouse dies, I want to give everything to my kids 3 ways, equally. That'll work. When is my estate subject to death taxes? For probably, unless somebody's holding out on me, everybody in this room probably is not going to have to worry about federal estate taxes. They certainly don't have to worry about Texas taxes. Now, the figure of $12.9 million exemption applies right now to every individual. I don't know, particularly if the Democrats get back in total control, they want to carve the death taxes out. I mean, you've been paying income tax all your life, and you've accumulated all this and pay tax on what you've accumulated, and now they want to turn around and take up to 40 or 42% of your estate, and because they can, okay. So, but I don't think they'll ever get low. I don't think it'll get that low that most people wouldn't qualify to just stay to not worry about it. If you do, then there's other trusts and things that can be done that involve probably getting a expert that works in that, including a CPA involved to help you with it. But again, I don't think you have to worry about it. One thing you can also be aware of, and I'll just mention in passing, that there is a federal gift tax. If you give something to somebody, you could be paying up to, that you or they have to pay 42% of whatever the gift is that's acquired. The exception of that is right now it's $16,000. You can give $16,000, and this is true in anywhere in the state and the country, and you don't have to pay any kind of gift tax on that. If, for instance, I wanted to, and I'm not inclined to do that right now if I could, if I wanted to give a big chunk of money to my children while I'm still alive, or you wanted to do that, you could give, if they were married, you could give each one of them, the husband and the wife, up to $16,000 each, and there's no gift tax associated with that. Some people will give portions of their estate and pass it on to their kids during their lifetime for 2 reasons. Number one, the kids need it, and it gratifies you that you can give cash proceeds or things of that sort to the kids. And there's other ways to avoid the gift tax, even if you're giving larger amounts. But you might want to talk to a CPA about the proper filing to do that. 9, what about life insurance policies and annuities and stocks and bonds and things of that sort? If you got a life insurance policy, you probably got somebody named as the beneficiary on that policy. Typically it's your spouse, or maybe if you don't have a spouse, your children. They're named as beneficiaries, payable upon death beneficiaries. Those proceeds don't pass into your estate. They go directly under the terms of the contract, insurance contract, directly to whomever is named the beneficiary. Now, let's say you've got minor children, your spouse dies, and you've got your 3 children named as minors, the challenge could be once, let's say they're 18, so they get the money and you're saying, oh my gosh, I've got a $100,000 policy, they're each gonna get $33,000, and they're all gonna go out and buy cars or do something stupid with it. They're not gonna use it for education or whatever. So just be aware that those insurance policies are really good to have, particularly when you're younger and you want money for your wife, let's say, or your husband, to have money to help defray the cost of caring for the children as they're growing up. So that's a good part of estate planning, is having an insurance package, one that you can afford with whatever the limits are. And I'm not here to tout life insurance, but it can be an important vehicle. All of that, unless you direct that those proceeds go into your estate, they will pass outside of your estate to whomever is named as the beneficiary. And get back on track here. It's the same is true with any other thing that you may have. For example, let's say you have some checking account and you have payable upon death directions there. When you die, whoever's named as the beneficiaries on your checking account or your savings account or your stock brokerage accounts will be paid. They'll go directly to them. They do not pass through probate. And a lot of times that's a good way to avoid probate, is to have everything that you have as you pare down and you get older and you don't need a lot of things. You can have a beneficiary named in your contractually with your insurance, your stock, or your savings account or checking account, so that when it dies, all they need to do is deliver the death certificate to the bank or to the stockbroker, and they will make disbursements according to whatever instructions you gave to them as to who the beneficiaries are. It might be the spouse, or the spouse has passed away, maybe the children. What does it cost to probate a will in Texas? I talk a little bit about that when I get to the part about frequently asked questions about probating a will. And I'm not going to elaborate on it, but to say, in my experience, most of the wills I probate can be done for around $2,000. And I know, to be honest with you, I'm probably on the cheap side, but most people, it's important to me that they get their estates in order. So the filing fees right now are just under $500. That's the cost that you're going to have. And then there's, if you have to run a notice, if you're named as the executor of the estate, you got to run a notice to creditors. That's all done by the lawyer. You don't have to do any of that paperwork. The lawyer will handle all that. But typically, they're going to charge between $250 and $350 an hour to do it. And typically, they should be able to give you a pretty good idea of what the cap is going to be on that. And then you just sort of, and again, if you need it done, but you can't afford it to do it until after the will is probated, they'll work with you. Most lawyers will work with you on that. All the ones I know are very good about trying to make sure that you get this done. They try to help you save money, and they're going to try not to overcharge you. There are exceptions to that, but again, the lawyers I work with are typically very conscientious about wanting to save money and help you save money. And again, that's part of why you do a will and do the powers of attorney, is to cut those costs. I get a lot of questions about I'm up to number 11. Can I avoid probate by using a living trust instead of a will? Well, people like those that are in California and in some other states, particularly up north, where probate is a lot more expensive and a lot more cumbersome, what people have done there is they put everything they have into a trust. The challenge with that is twofold. First of all, it takes a lawyer a lot more time to do it. So those run anywhere from $5,000 to $10,000, sometimes more, depending on the nature of your estate. And you have to make sure you get everything, your car, your home, whatever real estate you have, you want to name that and put it in the trust. Because if it's outside the trust, then you may still have to probate your will. So if somebody does a trust, they're typically gonna have what's called a pour-over will in that, which is if something happens and and you still have to probate the will because it's not in the trust, then you can, you may still have to probate the will. Typically, those are called living revocable trusts, meaning that you can, at any time, change who the trustees are or terminate the trust and pull all your assets out of the trust and so forth. But all of that costs money. So when would I recommend a trust? We had a lady whose husband died not too long ago, good friend of mine. They really had a very successful business here in town, and she was probably worth $15 million or so. And I sent her to a specialist in town that handles those kinds of things because I knew it was going to be complicated, and I just didn't want to mess with it. I didn't want to have to deal with that. I'm trying to lower the threshold of work, not elevate it. So I gave her to somebody that was really good. But typically, if your estate is under like a threshold of 12.9 million, you don't need to avoid the taxation issues that you'd find in other states, okay? Like California and other states that have inheritance tax on top of the federal tax. The only other time when I've seen it useful is if you have real estate holdings in more than one state. Because if you've got, let's say you got property in Louisiana and property in Arkansas and property in Texas, for example. Maybe you inherited something from a parent in Arkansas or a uncle or an aunt who lived in Louisiana, and they want to give you something, oil and gas or whatever, okay? And again, for most of us, that's a nice problem to have. But when that happens, if you die, you certainly probate the will where you live, or let's say we all live in Montgomery County, most of us do, then you probate it here, but you may also have to probate it in the county or the parish where that property is. So you'd have to do what's called an ancillary or a secondary probate of the will in other states. And then their state law applies, including whatever inheritance tax there are and so forth. So unless you have real estate outside the state, then you probably don't want to do that. From time to time, I've talked to people that do have property in other states, and I say, what are you doing with it? Well, I inherited it. I'm not doing anything right now except paying taxes on it. I says, have you ever thought about selling it? And putting that proceeds into something else? If nothing else, you could, a CPA could tell you about a 1031 transfer where you sell the assets in one state and transfer them and buy property back in Texas, and you don't have to pay any kind of taxation on that under federal law with what is called a 1031 transfer. I'm not trying to get in all the technical terms here. That's why you retain specialists that do this kind of stuff. But you can avoid those tax consequences or probate consequences when you die. Okay. Again, to reemphasize, I get so many people that tell me, well, they call me and say, I want to set up in a trust. And I say, why? Well, I want to avoid probate. And I say, why? Do you live in, number one, do you live in Texas? Yeah. Do you have any real estate outside of Texas? Well, no. And is the value of your estate in excess of, say, $13 million? Of course not. I say, then my question is, why are you doing a trust? Why are you spending thousands of dollars setting up a trust, transferring assets, real estate assets into the trust, and all that with that kind of an estate? Don't worry about it. We're going to do a simple will. We're going to handle everything that needs to be handled, and it's done. Okay, what is a transfer upon death deed? This is an interesting vehicle, and we talked about ways to try to avoid probate. Obviously, a handwritten will doesn't avoid probate because you're going to still have to probate that will. Okay, Signing a will, incidentally, a lot of people say, well, I got a will, that's all I need. No. You got a piece of paper that says, prepared, let's say by a lawyer, properly executed, that says what you want to do with your estate. But nobody's going to recognize that until a judge recognizes it, which is why you have to have that will probated before a judge, so a judge can say in about 3 to 5 weeks after we've, you come to the lawyer's office, hey, this is now a valid will. I, the judge, have looked at it, I've checked off everything, it meets the law, I claim it's a valid will, I issue an order that says so, and the clerk can issue what are called letters testamentary. It's a one-page document, they cost about $2, they're not that expensive, and you can use that and walk wherever you need to go and show that to your loved one's bank or a stock brokerage or wherever, and have the assets transferred to wherever the will provides for in the estate. So, a lot of people say, well, I'd rather avoid that. And I said, well, what do you have? I said, well, all I got is got my home, which is paid for. I don't really have any debt. I'm 75 years of age, I don't have any debt. And I've got a bank account and a savings account, maybe a little investment account. I said, well, one way to avoid probate, and I would probably still recommend they go and have a will as a stopgap for anything that might arise that we weren't expecting. But you could take that home and transfer it, have a transfer upon death deed, cost $200 to $300, and transfer your home or your real estate to a particular loved one named in that transfer upon death deed. It's revocable, meaning you can change it at any time. But if you die, that's been recorded at the courthouse, and all you got to do is prove that the person's dead, and that property will be automatically transferred to whomever is named. Again, there's a downside to that. If you got minor children, you don't want to transfer that to minor children because they're not capable or prepared to handle that. But if you got grown children, that might be one thing you could look at doing, is a transfer upon death deed. A lawyer could help you with that. And again, the payable upon death beneficiaries provisions is very useful. A lady comes in and she says, my husband's died, all I got is my home, and I got a checking account and a savings account, and I got 2 children, and I don't have any debt. And I've already taken care of my funeral arrangements, this, that, and the other. I say, well, what we can do is a transfer upon death deed, and we can verify, you check with whoever your savings account or lenders are, or whoever you've got your money invested with, and make sure your 2 children are named as the beneficiaries, and they're probably not going to need to probate the will. I've had that come in. People come in and say, I need to probate the will, and we sit down and talk, or sometimes I just ask the questions over the phone, and they'll tell me, and I say, given what you're telling me, I don't see any need to probate the will. You've already, the estate's already been transferred, and so forth. So those are things that you can do that may help avoid even having to probate a will. Another question I get, what is a guardianship? We're getting close to the end now, but let me just say this. It's legal authority to help a loved one with his person or estate. If you got a loved one, let's say your mother or your father, who is really fallen into dementia, or they're making some poor decisions, if they have a power of attorney and the right kind of documentation, you would have the power to act as their agent to take care of their personal affairs for them. If you don't, then you may have to hire an attorney to get appointed as their guardian, their legal guardian, to take care of them. Or if they're, occasionally somebody has a mentally ill person, a child, and they're now, they got Down syndrome, or they got some issue where they're not capable of taking care of themselves, and now they're 18, 19, 20 years of age. It's very possible that you may have to set up a guardianship for that person. And then you just go to court, you hire an attorney. It's not that difficult a process. You do have to have some medical affidavits stating that this person is not capable of taking care of themselves. And then that individual can be named as a guardian during the course of that person's life. They have to make an annual report to the court to make sure they're doing what they're required to do, because that person has become a ward of the court. That elderly person or that child or that person that's mentally limited becomes a ward of the court, and the judge has a legal responsibility to make sure that that person is not taken advantage of by having their estate ripped off from them or their care not being proper. I'm wrapping up. Number 15. Getting your financial advisors involved now. I think that's a really important thing to do. If you have somebody that's your insurance agent or somebody that you use as an investment planner or something like that, get them involved right now. If not, at least the last thing is getting your family members involved. The older you get, the more the chance are that something bad's gonna happen to you, okay? You know, I went to a funeral recently of a really healthy guy, David Thornberry, who was 49 and had a heart attack. You'd have never guessed it. He was a very successful businessman. He left a lot of stuff. But hopefully he had wills and so forth. I don't know whether he did, but hopefully he did. But, you know, for Martha and me, we've got a list of everything we own, our insurance, who the phone numbers are, what our account numbers are, and everything. So if something happens to us, our daughter Emily and our son Daniel know where everything is. And they have copies of our wills, or they should. I think they still do. And they know where the originals are. Okay. I can't tell you how many times I get a phone call. It happens 2 or 3 times a year. We've done a will for somebody, or somebody thinks I've done a will for somebody, and they say, my mother died and I can't find the will. I cannot find the will. I'm panic stricken. What do I do? I says, well, do you have a copy of it? Sometimes they have a photocopy, and that's fine. We can get the photocopy introduced. You've got to have witnesses to prove that up, but it's not that hard to do. Sometimes they can't find it, and we keep our will files. We keep a file on everybody we have. Now, quite honestly, by the end of the year, my secretary is going to be calling everybody that we have a will form for and telling them, we're wrapping up this practice. We're getting out of the probate business and maybe other work as well, but we're getting out of that. We got all these wills, copies of them. If you or your children want them, come by and pick them up in the next 60 days, or we're shredding them. So, when you got a will, make sure other people have them. And unless you're disinheriting somebody, one of your children, sit down with your kids and let them know what's going on and what your mental thought process is. Even when they're just teenagers, they should understand what's going on. And it also helps them understand why you love them and what you're trying to do for them going forward after you passed away. Also share, if you really got minor children, share it with the people that are going to be the executors of the estate if you and your wife are gone. Your brother, your sister, your best friend, whomever you're going to use, make sure they have a copy of it and they know what your thought process is. At least give them a copy, and also tell them where you're going to keep the original. And it can be kept anywhere. A lot of people will keep them in their gun safe, you know, or they keep, if they don't have a gun safe, I've had people wrap it up and seal it up and put it in their refrigerator. Because if they've got a fire there, they're more than likely They may be, smoky or whatever, but they're not gonna be totally destroyed, they're still legible. So, something of that sort. All right, I've covered everything, I know you have questions, and I'm here to answer those questions. And then, as I said, when we finish that, if anybody wants to, I'll spend about 20 minutes going through the small estate worksheet. And what I told Dave, I said, to the degree that we have time, I'm happy to do wills and powers of attorney for anybody in the church at no cost. If you feel like you want to compensate me, but what I'm telling you is give that money as a love offering either to the church or to some mission program that's part of your heart, Gideon's or whatever you want to do. Because I'm not going to accept your money as a member of the church. But, and I'm not saying that because I'm such a wonderful guy, but I'm saying it because it's awkward for me to be promoting all of this, and then people say, I want you to do my will, and I want you to make money off of this. I'm not here to do that. I'm here to make sure you are good stewards of what God has given you now and well into the future. You understand that? Okay. But to the degree that we have the time, and my secretary right now has a lot of time because a lot of my practice doesn't require her engagement. So she's sitting around with nothing to do. She could be doing these wills, and she could be doing these powers of attorney. And she can knock them out. Once I have a will worksheet, what I do is I prepare it, I give it to the people to look at the draft to make sure that the spelling is right and so forth. And then they come back and we have them executed in front of 2 witnesses and a notary.
The people are executed or the will is?
It depends on how awkward the situation is. Okay, questions? And remember, there are no, Roger.
Just one thought, I know 16 there, my dad and my mom passed away a couple years ago and I was the executor. And my dad had not told me any of this stuff, but I knew where to find everything. So he had everything filed away, all insurance policies and auto policies and all
Yeah.
that. So that is huge, just to not only have a will, but to be organized with whoever's coming behind you to know where to find
I
something.
can't emphasize that enough. Even if you've got a small estate, you got a checking account, you got a life insurance policy. How do they know you have a life insurance policy unless you get some paperwork in the office and they're rummaging through all your desk and files and they find this stuff and they go, oh, he may have had a life insurance policy. When my dad died, he'd been out of the service for probably 40 years at that point. But he had a veterans policy that he'd acquired 40 years ago. It was only about $5,000, but we wouldn't have known we had it except he had put that on a piece of paper. And so I had to do some checking to find it, but I was able to do that. Other questions?
Larry, how
Yeah.
difficult is it to change your will and how often should you? So like our kids they're turning 18 every 2 years. So will we need to change it every time we have a child?
No, not necessarily.
Okay.
For instance, I don't know if you have a testamentary trust for the minor children in there or not. Most people don't unless you go to a lawyer. But if you die, if you and Bobby are dead, Don, they're going to get whatever you got there, and whoever the executor is. Now, the things you may want to look at as they get older is, do you want to change the executor? Maybe the executor's died or fallen out of favor with you, or it's something they don't want to do. Because by executor, I'm talking about assuming you and both of you are dead, you'd have an alternate, or maybe even a second alternate. You might want to check your will every few years to make sure it's still current.
And then how do you change it?
Well, there's 2 ways to do it. One is to simply do what's called a supplement to the will. The term is codicil, C-O-D-I-C-L-E. Codicil is simply a supplement to the will which references the will, the date of the will, and says, on paragraph so-and-so, I want to change paragraph so-and-so to name so-and-so. Or change the paragraph dealing with executors of the estate, I want to name these. a lot of times, it's just as easy for a lawyer to just do a new will, because you still have to have witnesses and notary to do the codicil. A lot of times I just tell them, hey, for the same cost, I'll do you a new will. Next question. Yeah, Greg?
On this transfer upon death deed for real estate, does it affect the title? Which is an important issue for people who are over 65. You don't want to lose your exemption.
No, it's only effective upon your death, so you still have your homestead exemption. Good question. Yes, ma'am.
So I have a question about the guardianship. My grandmother has a brain disorder, so she has a guardian. She's had one for several years, but we've had a lot of tremendous difficulties with her. How can we go about changing that? Like, how do I get a lawyer to change the guardianship?
Well, I'm assuming when you say guardianship, she has a court-ordered guardian.
Right,
And if that guardian is not doing what that guardian's supposed to do,
right,
and that guardian is not willing to give up the guardianship,
right, because we would like to take over.
then what you need to do is retain an attorney to file a motion with the court to remove the guardian and have a new guardian named.
Okay,
And so that the lawyer can help you do that.
okay. Thank you.
John?
Yeah, I'm, in California, and I had a property, and I had a trust and a will, set up there. It was not entirely complicated, but there's some details in there. And then when I came over to Texas, since my trust was written under California law, I have to get it redone under Texas law, right?
No. The trust is still valid wherever you live.
So once I already have the trust, it's already there, I should just keep it.
Yeah. The question you want to ask is it still current? Does it still say what you want to say? Because you can amend your trust. We do those from time to time. No, and in all probability, the will that you did in California, if it was probated in Texas, because I know you have a home here, would probably, if it's got if it has two witnesses that saw you sign it and a notary that saw you sign it, the will should be valid here. Now, what we sometimes have to do is file with the court information for the court to take what's called judicial notice of what the law is in California, so that the validity of the will as drafted in California can be recognized in Texas. That's not that hard to do. Fortunately, with Google, I do that. I can get the law real quick in another state.
One follow-up question, regarding the original documents.
Do what?
Regarding the original documents,
Uh-huh.
those are important, you need to keep those safe, right?
Yes, the trust and so
What
forth, yeah.
happens if they get destroyed?
Well, they're still gonna have, I mean, for instance, you got real estate in the trust. Some people will actually record the trust at the courthouse where they live. And if it's recorded, you don't care whether it's lost or not. It's still a legal document of record. Not everybody does that, but a lot of people will do that, particularly if they have real estate. And your lawyer probably did that for you over there. Okay, Leah.
In lieu of people, are there institutions or facilities that could act as executors?
Yes, good question. But they're gonna charge you something like 5% of whatever the assets are in the estate. So you could name a bank to do it for you, or some other agency, but typically they're gonna do it for a fee. So it's gonna cost the estate to do that.
We're
Great.
talking about an executor there. What about someone that manages, like if you don't have children and your other spouse has passed and you're no longer competent to manage your financial affairs, can you hire like a fiduciary to do?
Oh, yeah, I mean, yeah, you can name somebody to be the agent or the power of attorney while you're alive, and then name somebody as the executor of your estate once you die. But again, you're better off if you can't, bless you, you're better off if you can find somebody that's a family member or somebody you trust. Sometimes a stockbroker or a good friend like that would do it for you, but they have to charge you because it's an imposition on them that they really don't want to do. I made a mistake early on because I was so naive that occasionally people would say, I don't have anybody, would you be my alternate executor? And I said yes, and then I was the executor to have to handle it, and it was a mess because I wasn't getting compensated for it other than whatever my expenses were. So I never do that anymore. But it's amazing how many people say, can you do it because I don't know anybody I like or trust, or I don't know anybody. So make sure you are in control of who you want. Don't let some guy who's an agent for a bank, and they move around from time to time, do that. Other questions? Yes, Lynn?
I have a couple of exceptionally dumb questions.
There are no dumb questions.
On the federal gift tax, the $16,000 to loved ones, et cetera. If you give the $16,000 to each of the parents, can you also give $16,000 to each of their kids?
Yeah, you can give $16,000 each year to any individual. So you can start dispersing your estate in advance, assuming you know that you're going to have something left for your old age, And another thing, I encourage people, I get a lot of people in their 70s and 80s that are coming in, and I tell them, they start talking about, well, I want to give my great-grandmother's rocking chair to my daughter, and I want to give my son my dad's shotgun. I said, well, are you using the shotgun anymore? Well, no. Well, are you sitting in the rocker and using it every day? Well, no. He says, give it to them now. Let them enjoy it, and you enjoy them enjoying it while you're alive. Don't hoard this stuff. Martha and I are trying to get rid of our stuff right now, and fortunately, now that we got a son that's married, he can take a lot of this stuff. Because he and his wife don't have any, didn't have any furniture to speak of, so we've been happy to give them things. But when Martha's mother was passing away, she was giving away china and silverware and all kinds of stuff to all the grandkids who could use it. And it brought joy to her heart to do that. So, Lynn?
The other one is payable upon death for savings accounts, bank accounts, so forth, retirement accounts. If it's a co-held account, like a checking account or a savings account, can the payable on death go to the other person?
Well, let's say husband and wife own a joint account, like Martha and I do. If I pass away, she's still on the account. So she still writes checks and so forth and so on. The only time that if they're both dead, you can have arrange for a person to receive it. And what some people do is they'll have a small, they'll have a reasonable checking account, maybe 5, 10, 15, 20,000 in the checking account, and they'll have maybe one or two of their children named as payees on that, so that they have money to take care of the paying the funeral expenses and medical expenses and so forth. So they don't strain their children because they have that they can do. And sometimes those children are also signatories on the checking account, which means they can write checks during that period of time.
So the bank would, if it's co-owned, the bank wouldn't freeze the account when they find out one of the owners is
They should, as long as it's co-owned. And frankly, they're not going to know. Typically, they're not going to know.
When the Social Security checks stop coming in, they'll know.
Yeah. Other questions? Okay. If you wish, I'll be happy to walk through the small estate worksheet with you. Just familiarize yourself with some of the stuff that's going on there. If you don't, if you need to leave, go on and leave, that's fine. I don't know if we're gonna have time to record the other portion of that, it's iffy. Okay, for anybody that wants to, I'll walk through this small estate worksheet. Different lawyers use different forms. I use this one because, first of all, it's easy for my secretary to follow, because I just do all this and I give it to her, and then she prepares it, and then I review it, modify it as need be. So let me walk you through this real quickly, for anybody that cares to. Obviously, I need to know whether you're married or single or divorced or widowed or whatever, because sometimes that's referenced further in the will, or at least we know to ask the question. Am I preparing this for both spouses? We only need one document, one worksheet for both couples if you're married and you want to do one together. We like to know, we need a county of residence, mailing address, street address if the mailing address is not the same as the street address. We need contact information like a cell or home number, email address, the spouse's full name and her contact information. We need a list of the children, that is the full name of the child, the city, and the state. Top of the next page. If you have children by a previous marriage, I want to know who the spouse was to those children. Is that spouse still living or dead? And the names of the children, again, their full name, city, and state. Then spouse's children, your stepchildren, in fact, by marriage to whomever your spouse was married to, and whether that spouse's person, that ex-spouse, is still alive or dead. That's important because if you got minor children, bear in mind that your guardianship, the other spouse may be entitled to guardianship of the children when the spouse who has the children by court order has passed away. Then special bequests. If you want to make special bequests before you're giving something to your primary beneficiary, like I want to give the money, the property I inherited from my mother, I want to give it to my 3 children now, and not pass it on to your spouse. You can do that, or any other special bequest you may want to make. Then the general bequest is your primary beneficiary. If you're married, typically you'd say spouse. We'd know that that's going to be the spouse. Then alternate children, your children, you want to give it to them equally. Do you want to include your children and stepchildren? There's a place for that. Or any other request you might want to make. If you don't have children, the alternate bequest, if primary beneficiary and alternate beneficiaries are dead, who do you want to give your estate to if all your primary beneficiaries and alternate beneficiaries are dead? Sometimes if that happens, you may have a sibling you want to give it to, or you may want to give it to a charity or whomever. Page 3, again, specific bequests. You can make specific bequests to an individual, either a family member or a friend, and describe the property that you're giving. And then you want to name the spouse. Typically, the spouse is going to be the executor of the estate, but not necessarily if you're single, or if the spouse is incapacitated, you may want to name somebody else. And then you have a backup, a second alternate, and maybe a third alternate there for these named as executor. If you have minor children, you may want to name guardians so that you declare who you want to raise your children. Be sure and let them know that that's what you're doing. and get their permission before you do that. And if they can't serve, or if something happens to them, you might want to have alternate guardians listed. If you have minor children, you may want to set up a trust, a testamentary trust within the will. And each child's age, and you set there the age, and it may be, it could be 18, if you just trust them, or 21 or 25. Typically, I don't recommend beyond 25. You want to get them through college or get them off in the workforce before you give them the estate, but you don't want to wait too long because that becomes a burden on the trustee who's responsible for the day-to-day disbursement of monies to these children during their lifetime. Top of page 4, alternate trustees would be listed. Then disposition of remains. I like to put in the will whether or not you want to be cremated or buried, and if you want to be buried, where you want to be buried. A lot of people have a family plot, so they will list that where they want to be buried. And if they're cremated, sometimes they even have specific requests. I want my ashes, a lot of times they'll just say, I want my ashes to be disposed at the direction of my executor or the direction of my children. But a lot of times they may say, I want my ashes spread over Lake Conroe. Or I want them spread from a helicopter at 5,000 square feet over some land I own, or something nuts like that. So I've seen all kinds of things. We also have a place for special instructions. If you've got special questions or instructions, then that's a good place to put them in there, because that may raise a red flag, and we'd call you to say, hey, what did you mean by this? Then the 3 documents that I recommended earlier, a durable power of attorney. Typically, the spouse is going to be named if the spouse is capable, or if you're married. If not, it could be one of your children, an alternate's named, or someone else that you trust to take care of your affairs. The same is true with your health care power of attorney. Typically, anyone that you want to know that might come to the hospital if you're ill and the doctor needs to confer with somebody about a medical procedure that needs to be done. And then finally, the do not resuscitate, the directive to physicians I'm talking about again. Family members are typically the people you're going to want to tell them whether or not you want to be kept alive on life support systems, if it's terminal or if it's an irreversible condition. And again, you need to consult with them and make sure they understand what your feelings are. I mentioned here that no fee will be charged to members of Conroe Bible Church. You're invited to make a special offering to Conroe Bible Church if you wish, or any other charity you may wish. Unless time is critical, the draft will be prepared in the order received and as time is available in our office schedule. And then I need to know whether you want us to email it or mail it, or I can just, if you're coming to church, I may just bring the envelope to church and hand it to you at church. Then, the very last part, in order for us to be satisfied that your documents are properly executed, we recommend that all your wills and powers of attorney be executed with me present to assist you by appointment either at our Conroe law office or after church. In other words, we could do it after church. I just bring my notary stamp and grab a couple of people that are not inheriting from you to serve as witnesses. Each document must be executed before 2 disinterested adults who can attest to your signature before a state licensed notary public who is also present with you at the execution of the documents. I can serve as the notary. That's a quick overview of it. Questions?
If both Danny and I were to go at the same time, or even, well, I guess even, is there such thing as like dual executors, like we wanted Georgia to be?
You can be,
Okay.
you can have co-executors.
I mean,
Co-executors name, yeah.
okay.
Good question, I forgot to mention that, yeah. Okay. Okay?
So if we give this to you, within the next couple of weeks or something like that, or is there a time?
Well, it's a first come, first served basis, so if I got 50 of them, I may not be able to get to all of them.
Right.
So take whatever time you need. I'm just gonna try to get them when I can do them. And, you know, I'm sort of at the mercy of my secretary, because right now, our office is in limbo. My partner's leaving at the end of the year. My secretary is the only one left in the office. We have directed our other two staff members to new jobs. They're still helping out from time to time, because they're like family. But I don't do this stuff. I could, I just don't prepare them. It's too time consuming for me. She can whip it out like this. For me, it just takes too much time for me to do it. That's why if she's available and she's got time, she'll do it. And she should have plenty of time to do it in the next 30 to 60 days.
Just give it to you at church or whatever?
You can give it to me at church, yeah. And we're usually here.
Yeah.
Or Martha.
Oh, yeah.
You give it to Martha.
Oh, yeah.
And then I'll look at it
Okay, just give it to
to see if I have any questions, but then we'll just start cranking it out. You'll get a draft to review before the final is done. Other questions? Erica, do you have any questions? You're not Erica. Who are you? I can't remember.
I'm here.
Well, I thought you were Erica.
Oh, yeah. No, I wrote everything.
Okay. Good. All right. Anything else? All right, well, I'm happy to do it, and if we've got extra documents up here, if somebody wants to pick up some of this other stuff, just as